Things are starting to get really interesting with U.S. immigration. Can Donald Trump give you a green? Hey guys, before you file for your spouse, hey guys, come on in. Let's have our Monday Q&A session. I'm Latoya McBean Pompey, an immigration lawyer working with clients nationwide at McBean Law, where we believe that freedom is now. Join me, family. Come on in. Say hello, hello, hello. Hey there, Nicholson. Thank you for being here. Hey there, raise your hand. Freedom now, freedom now. Brulin, thank you. I hope you guys had a terrific weekend. Brulin is in Florida. I hope that you were obviously safe last week. Freedom now, Liz. Good to see you. Hey there, Karen from Yonkers. Thank you. Just give me some freedom now and tell me how you're feeling today. So we're going to have your answer immigration questions. All right. This is our time together to do that. I hope you guys have been enjoying these live sessions. Thank you. Hey there, Alva. Good to see you. Adiola, nice to have you. Where are you guys watching from anyway? Tell me what city and state you're watching from today. I think my mic is a little bit high. Give me a second, guys. I'm going to make the adjustment here. I think it's too high. So let's just turn it down just a little bit. All right. I guess I'm just so excited. Good to see you guys. Hey there, Denise. Freedom now, freedom now. For those of you who'd like to go deeper with us, you know the drill. Contact us by calling us. Our new phone number, which is a local number, which makes it easy for us to reach you. Easier to reach you, certainly. It's 914-898-9488. You may contact us to book an appointment with us, either here in White Plains, New York, or at the Forest Hills, Queens office. Freedom now. Hey there, Seymour. Good to see you. We had a busy weekend, of course. I worked yesterday. We had a terrific market and event to go to that I was a part of, and it was wonderful. I got a chance to meet a lot of people, and it was amazing because I met this woman. I was just walking into the building, and this woman said to me, "Hi, Attorney McBean." And I was like, oh, she knows who I am, right? And she says, I have an appointment scheduled with you for the end of this month. I'm on your calendar. So it was so amazing, guys. You guys are the best. You're out there. You're real. And I so enjoy getting to meet you when I can. So you could have your in-person meetings with us in White Plains and in Queens, or you can meet with us virtually by Zoom or by telephone. Okay, so come on in and say freedom now, freedom now, freedom now. Freedom now. I thought the first question that I saw was about parole in place. Let me see if I could go back to it. Colette is asking, are there any updates on parole in place? So Colette, the main updates that I've been sharing are about important dates that I think you need to pay attention to. And so in this case, we're talking about certainly November 8th, which is the date when the current stay is slated to be lifted. But before that, a few days before that, November 5th is the date that the court has set to maybe have a bench trial on this so that the judge can make a decision. Sounds like it's going to be a quick one, and wrap this thing up on his docket on the district court level. That's the only update I have at this time. I know that various organizations are trying to do other things right at this time. I'm just focusing mainly on the big picture issues with this litigation, and hopefully we can get the right outcome for parole in place. So stay tuned. Lastly, USCIS is still accepting applications. Whether you decide to move forward with it or not, that's your prerogative. They're moving forward with collecting your fees and having and issuing biometric appointment notices. All right. So that's the only update I have currently. Check out last Friday's immigration news summary for other news that I shared from last week. Thank you. I see that Atlanta is in the house, Long Island. Thank you. Hey there, Leslie. Awesome. Thank you. New Rochelle is in the house. Our neighbors. You're very close to us. Thank you. Okay, so let's see what other questions you have. I'm scrolling down. The Gambia is here. Awesome. Let's see. Okay, Anne is asking, can a child file for both parents? Hey, Anne. Can a child file for both parents if the parents are not married? An adult U.S. citizen, son or daughter, can certainly file for his or her parents, whether the parents were married or not. They could file the I-130 for the parent if the parent is overseas. If the parent is here in the United States, it's an adjustment of status process that child or the adult son or daughter would file for the parents. All right. Thank you, Martinez. Good to see you. Freedom Now, guys. Come on in. Say hello. Freedom Now. Kojo. Patricia, follow me on Instagram, where I also go live, and TikTok, and get into my stories and see what I do behind the scenes. Thank you. Hey there, Joy. Thank you for joining from Trinidad. All right. All right. Any update on the parole documents? Which parole documents are you referring to? Actually, I did answer a question about parole in place already. I'm not sure what documents you're referring to there. Thank you. Let's keep going down. Nice to see you guys. Awesome. All right. Someone says that I'm a resident. Can I get a visitor visa for my nieces in Mexico to visit me? I want to take them to Disneyland. So there's a process for folks to fill out the DS-160 visa application and get a visa to come here, of course, for tourism purposes. And it's the same process for everyone, regardless of whether they're in Mexico or anywhere else. They could just give it a try and see whether it will work for them or not. Okay, so it's the same DS-160 online application process and then an interview at the U.S. Embassy. Thank you. Thank you. Let's see what else you guys have. Type in Freedom Now, and thank you for joining me today. Someone says, is there any avenue for a 16-year-old who overstayed by 3 years, really don't want her life on hold because of not being able to go forward after high school? So does the 16-year-old have a parent who can file for him or her, for her? That's the question. And because this 16-year-old has overstayed the visa, the 16-year-old will not be eligible to do adjustment of status. That child will have to go back to a U.S. embassy when the time comes to finish the process there. So that 16-year-old will need that petitioner. Now, the other way that some young people who are eligible for this, some young people can get a green card on their own through a process known as Special Immigrant Juvenile Status, SIJ, which allows them to make an argument in family court, and firstly in family court, and then secondly to immigration, arguing that they've been either abandoned, neglected, or abused. And those words, I know those words sound like, oh my God, no, I don't, the child was never abused or abandoned or neglected, but those words have certain meanings within state law. And you'd be surprised to learn what neglect actually means or abandoned. So speak with an immigration lawyer. You could contact us to see if that child might be eligible for this particular process in which he or she can move forward with a green card on his or her own. But it's really a two-step process, so to speak. The first step does involve a family court process in the state where that child lives, and then the second step would involve immigration filing. All right, thank you. So again, that's called Special Immigrant Juvenile Status. Someone says, please tell me, I've been documentarily qualified since November 2023. How much time? Priority date is 2005. So a visa is already available for you, right? Visa is available because you got as far as being documentarily qualified at the NVC National Visa Center level. You've gotten very far. You're just waiting now for an embassy interview. So what I would be focusing on right now is certainly, will I be prepared for this interview? Okay. You could speak with a lawyer about what steps you need to take to prepare yourself and make sure everything's in order. But for the most part, some embassies are still very slow with issuing dates. So hang in there. It sounds like you're at the tail end of your process, okay? Hey there, John. Thank you for that. Thank you. I appreciate it. John Leo, Freedom Now. Can I repeat the number? Sure. And the number, by the way, is scrolling below. The number is 914-898-9488. It's scrolling below. Or you could just go to McBeanLaw.com and you'll see that information. Thank you. Robin is asking, is the estimated time until case decision on my USCIS portal accurate? Robin, I'm not even sure. I'd never get involved in anything dealing with their portal. I don't know. From time to time, I do tell people things like don't rely on those dates, only because I hear from some clients that USCIS those dates change. Sometimes they then live Q&A session here answering your immigration questions. Let's see. And a similar question, actually, Liz is asking, I have advanced parole. It expires in March 2025. If parole in place goes through, can I travel with that? So Liz, you have some time to wait and see what will happen with this litigation, right? You have time. So I wouldn't stress it right now, because by November 8th, we're expecting that this whole stay to be lifted and things to some decision by the judge, right? And so if the decision is favorable to the government, then USCIS, I'm pretty sure, will immediately start, I think, to issue these approvals or decisions in these cases. And then if you're one of those, Liz, who get a decision that's favorable to you, then you can certainly move right into adjustment of status. And as an applicant for adjustment of status, you can also get advanced parole at another time later on down the road while you're waiting for the green card application to be decided on. So I think you're in good shape. Just hold on a little bit longer, okay? Hold on a little bit longer. Thank you. I think you're in good shape. Thank you. Type in freedom now, guys. Hey there, Fantasia. Good to see you as usual. Thank you for always bringing your positive vibes and energy. Okay, if I file through my 21-year-old son, would I have to leave the country? Martinez is asking. You may have to leave only if how did you enter? That's what's going to determine whether you have to leave or not. How did you enter the U.S.? If you entered lawfully with a visa in your name, you would not have to leave the country and finish the process abroad. But if you had illegal entry, then you will not be able to adjust your status through the 21-year-old son. Okay, Freedom Now. Hey, Diana, Freedom Now. Thank you. Thank you. My husband has been, Mema says, my husband has been on administrative processing for 1 year and 7 months. What can I do at this point? You could sue the government. Certainly, you could sue the government by filing a mandamus in federal court to force them to make that next move. And that next move, when your case is like this at the U.S. Embassy, is for the embassy to issue some sort of letter letting you know that you need to bring back in, you need to update some documents for them, like taxes, latest taxes, and some other police clearance, so that they could get your husband back on track with his consular process and get him interviewed a second time. So you can contact us to discuss what could be going on there with your husband's case, okay? Hey there, Fabre from Indiana. Freedom Now, Amit, good to see you from Tennessee. Thank you. Is it possible to have an I-130 application filed while you have a VAWA case. At the same time, Anthony is asking, Anthony, you want to be strategic in what you're doing with immigration, because if you have an I-130 pending through a spouse, a U.S. citizen spouse who you're alleging to be in a bona fide marriage, and then on the other hand, you have a VAWA application, basically kind of like attacking that U.S. citizen petitioner and say, actually, she's abusing me and this isn't a good marriage, right? Things are bad with us. Well, that doesn't really make a whole lot of sense. So speak with us about, you may need to get out of that I-130 case or the 485 that's attached to that. But all of that, with respect to withdrawing and not the 485, the 485 can be used for the VAWA case. So let me just back up. The 485 can actually be applied to your new VAWA case. But let's speak with us strategically about the timing of these things and whether and how to update USCIS to let them know what the story is in your case, okay? So that there is no confusion. Thank you. Let's see. Lisa says, nice picture, Lisa. Good to see you. I expect my papers and the address I have and not get in my mail. What can I do? Should I change because I'm not there anymore? Lisa, I'm not entirely clear what you're saying here. You've moved and you're expecting your green card to be sent to you soon. I don't know if that's what you're saying there, but in any event, certainly whenever anyone changes an address and you're going through an immigration process, you must update the government on its website with your new address so that you can continue to get the mail. Most importantly, you will get your green card or work permit at the right time, okay? Thank you, Freedom Now. Come on in, guys, say hello. Say hello and say where you're watching from. Hope you had a good weekend. Let's see. Someone says that I overstayed H-2A visa, H-2A since 17 years. Okay. Is there an option for me to fix my immigration status? So this is someone who has overstayed for quite some time. To fix your immigration status, we would need to know from you, do you have a petitioner right now who is eligible to file for you? And if so, who? And you may or may not need a waiver, okay, to finish up your process and get your green card. It will also be assessing whether you have any humanitarian opportunities for a green card, right? Check out our success stories on our website to see how we've been helping people who have been here for a very long time. Those folks have a pathway to a green card. So look at those success stories to see what pathway each person actually had that helped them to get their green card. Freedom Now, it's good to see you guys. Thank you. Let's see what other questions you have. Martina says that I'm a U.S. citizen. I filed for my sister. Does she have to go back home to continue her process? Martina, your sister most likely will need to go back home and finish her process, but be careful with that, because if she leaves before getting a waiver approved, then she could be stuck outside of the U.S. for 10 years. So you want to make sure to have her speak with a lawyer before she leaves the country and finishes her process back home. However, for that waiver to work, she'll need a parent or a spouse who is a U.S. citizen or a green card holder. And that's the problem that most siblings face who are here in the United States going through this sibling process. They just don't have the family member that they need for this waiver. So then the process doesn't work out that successfully for very many of them. Not unless, certainly she's eligible under 245I, which we will also look for. If she's eligible under 245I, that's a way that she can get her green card here without having to go back home. All right, so we would look at that issue for her. Someone says that I have been here for 10 years. I came with a 5-year visitor visa. I went to school. I earned a bachelor's and a master's. I'm now working for the Department of Education, or is that Energy, DOE? How can I apply for a green card? Well, I would want to know, how is it that you're working for the government right now? Okay. How is it that you're working for the government, right? And you have your picture there and everything. Be careful. How did you get a government job and you don't even have a green card? All right. So you may want to start there with a discussion with a lawyer about that. And to get a green card, you'll have to have a relative or a humanitarian pathway that could help you finish that process, or even an employer and a waiver. It's complex on the employment side. But I would say to you, you should be very careful about these things, particularly what you put on my platform here about working for the government. Guys, come on in, lighten up, and let me know your thoughts as I'm going through this, okay? Barbados is in the house. What is the update for asylum case who has not received court date for master hearing? So Brian, did you enter the United States illegally and then you applied for asylum and you're immediately in removal proceedings and you're still waiting on your calendar, your first hearing, master calendar hearing? If that's the case, you have to just continue waiting for that date, because sometimes it takes ICE. If ICE is the agency that is going to be issuing this notice to appear in immigration court, sometimes it takes them a little while to communicate with the court, and then for you to get your hearing date and all of that. So sometimes it's an administrative problem, and so many thousands of new immigrants who came in the United States illegally have dropped out of the system. They've dropped off the radar because ICE never took this administrative step to actually place them in removal in court. Or for some people, they go to court and the court doesn't have their documents and the judge is dismissing these cases. And I've talked about these problems over the last year that our immigration court system is facing. So you're facing a little bit of a delay for your hearing. I don't know if it's one of those administrative problems that ICE has with the immigration court system. Or is it a situation in which you sent your asylum application to USCIS and USCIS didn't approve your asylum case and referred you into removal? Well, again, there's an administrative period of time that you'll need to wait to hear from the court to get your hearing notice. So that could be an issue as well. But more often than not, we see the first scenario in which ICE doesn't communicate with the immigration court properly. And so people just fall out of the system. And then they don't have their day in court to have their asylum case heard. And then the clock runs out. It gets really messy for a lot of them. So let's see. I am in the country for 22 years. My sister filed for me in 2002. I came 2001. But the law was passed. Is there any change? So your sister, any changes? So your sister filed for you after Section 245I cutoff, which is April 30th, 2001. So you won't be able to do that process, okay, 245I. In order to finish up, you'll just need a waiver. And it sounds like you're not even eligible for it, which is why you've asked this question. So we'll have to assess whether there's anything else that could be done for you on the humanitarian side only. Okay? Thank you. Let's see. Good afternoon. Good to see you. Thank you for being here. Let's see. Freedom Now. I'm not sure if this question triggers state law issues about marriage and age and all of that. I won't be able to answer any state law questions on today's broadcast. I'm only answering obviously immigration related questions. The legality of marriage is determined by a state, and the state sets its parameters, okay? And so, and the age limits and all of that. And if that state law, if you got married according to the state law and now you're doing an immigration filing, well, immigration is going to look to see that whether your marriage was legal under that state or not. Okay. And this type of issue comes up with age differences. It comes up with like cousins who want to be, who are married. Like those are state law issues. Okay. Let's see. Thank you guys for being with me today. Freedom now, freedom now. Someone says, what about a person who graduated from college with a social security card but overstayed their 5-year visa? Can they get a green card? Keisha is asking. Only if they have a petitioner and a pathway to a green card, Keisha. Guys, I saw this TikTok video this morning that really broke my heart about this DACA holder in Missouri. Okay, I'm just going to end it with her story. Okay, this might even apply to you and might help you. But she was on track to be a nurse. She went to school, graduated from nursing school. She's on DACA. She took her license and tests, and she went through so many obstacles to become a nurse, and she even landed a job, started working, only to eventually had to resign from her work recently because under that Missouri state law, it would not allow DACA holders to practice as licensed RNs, right? There's a problem in that state law that doesn't make it an exception for DACA holders who are here, who are able to work lawfully in the United States. And she shared her story. It was very heartbreaking. So I'm ending it here because I want to say to you that if you have a pathway to a green card, if you have DACA, we help folks with DACA. We have our testimonials, but in order to make it work for you, DACA holder, we look to see if you have that pathway to a green card. We look to see if you've ever traveled on advance parole. We look to see if you have a spouse who's a U.S. citizen. There are so many factors there that we're going to look at, but do move forward with your case if you have one, okay? Because the situation for DACA holders is really precarious these days, and it is tied up in that litigation on the Fifth Circuit, which heard the case last week, and they are, we haven't gotten a decision yet on the DACA case that the Fifth Circuit heard last week. But just know that DACA is temporary, and it's unfortunate that our policymakers really did not, they really toyed around with people's lives, truly, with respect to DACA. It's a very hurtful situation, okay? And on the one hand, it gave you such tremendous hope. Obama made that policy, made it possible, so much hope. And finally, for the first time, the 500,000 or so DACA holders were able to feel like with dignity, that they had dignity, they could work, they were lawful here, and for some of them they could travel. But then something like what happened to that young woman in Missouri happens to remind her that this is the ceiling that we've set for DACA holders in the state of Missouri. You can't become an RN, you can't work in a hospital, you can't do this, you can't do that, and it's very frustrating. Other states, they could go very far with their DACA status, but some other states, they just cannot. So know your state law, know the rules before you undertake these very expensive steps to become a professional licensed person in your state. Check out these rules first. Make sure you understand them carefully, particularly if you're in health care. All right, guys, thanks so much for being with me. I will be live on social media throughout the week. Follow me on Instagram and TikTok at McBean Immigration Law, and be sure to call us 914-898-9488 to meet with us. Thanks so much, guys. Have a wonderful afternoon. Bye-bye.